Court calls the cases of the People versus Terry Probst.
Good afternoon, Your Honor. Raymond Cook for the People.
This hearing opens like many others, routine on the surface, but underneath there's already tension building. You've got a defendant dealing with a bond violation, a defense attorney stepping in last minute, and a judge who has seen this pattern countless times before. And that's critical to understand here, because in court, patterns matter just as much as facts. Bond conditions aren't suggestions, they're strict legal obligations. When someone is released on bond, they're essentially being trusted by the court to follow rules like reporting, testing, and staying in contact. The moment that trust is broken, even slightly, the court starts shifting from leniency to control. Now pay attention to how this unfolds. The defense is about to present explanations, missed communication, confusion, as attempts at recovery. But the real question is, will the judge see this as effort or as excuses? Because here's the reality. Judges don't just evaluate what happened. They evaluate credibility, consistency, and responsibility. And in cases involving missed tests and prior positives, the margin for error becomes extremely small. So as we move forward, watch closely. Is this a case of someone trying to fix their situation, or someone who waited too long to take it seriously?
And Assistant Public Defender Natalie Pate with on behalf of Mr. Probst. To my right, please state your name for the record, sir.
Terry Probst.
Thank you, Your Honor. Your Honor should be receive a green sheet. I'm respectfully requesting an adjournment. I was just able to make contact with him.
Counsel Probst, do you have the bond violation?
I do, Your Honor, and I'm also prepared to address
Okay, you ready to address it? Okay, go ahead.
So, Your Honor, as I was going to say, I just made contact with Mr. Probst this morning. He provided me a new phone number. I was able to review the bond violation with him. When he was reviewing it with me, he told me that he went to community corrections on December 29th. I did then email Ms. Dozier at community corrections, and she stated to me that this morning that she just had the front desk check in the sign-in sheet, and it appears that he did sign in that day.
The 29th?
Yes. However, it was not his day, and he would have been turned away unless we received an order from the court. Obviously, since then, Mr. Probst has had a lot of missed tests and did not go back to report. I asked him why, and he said that when he went on the 29th and they told him he wasn't on the list, he was confused, did not come back. I advised him that that was the wrong thing to do, and he should have continued contact with them and gone back to community corrections. He did also, Mr. Probst, that is, provided me with a document from Home of New Vision that he says is from 2 days ago. That does, I just received this morning, Your Honor, so I apologize. I was unable to provide it to the court or the people in advance. But it states that he's working with a Marcus Pollard at Home of New Vision, working to help get him through access. They are waiting on a follow-up communication so he can proceed with the next steps in his recovery, hopefully to get into rehab. That being said, Your Honor, I do have the documentation as from the Home of New Vision from 2 days ago that Mr. Probst provided to me. He is willing to engage in community corrections testing. I believe he is confused.
He's missed 15 tests.
That is true, Your Honor.
Now this is the turning point, and it's a big one. Missing 15 tests is not a minor issue. In the eyes of the court, missed tests are often treated the same as failed tests. Why? Because the system assumes avoidance. If someone is consistently missing tests, the court doesn't assume innocence. It assumes risk. And when you combine that with prior positive results for cocaine, the situation escalates quickly. The defense is trying to highlight something positive, his connection with Home of New Vision, potential rehab steps. But here's the problem: timing. These efforts are coming after a pattern of violations. And in court, late effort doesn't always erase earlier behavior. Judges often ask themselves, is this genuine change, or is this reaction to being caught? This is where the judge's mindset becomes critical. Because from a legal standpoint, the court's primary responsibility is public safety and compliance, not second chances without structure. So the real question becomes, is the court willing to gamble on rehabilitation or enforce accountability first?
Yes.
And the two that he took, which were actually in September, he tested positive for cocaine.
That is correct, Your Honor. And then he was in jail and released on December 23rd. And obviously, I acknowledge he has not tested since he's been released from the jail on December 23rd. But Positively speaking, he has been working with Home New Vision. He did go on the 29th. Again, he should have continued to go back, and I did advise him that that's what he's supposed to do. I would ask if the court would consider ordering him to go to community corrections today and possibly come back based on the test results.
I'll adjourn this to the 29th, 2026, 9 a.m. But at this point in time, the defendant needed to do something else. He has attorneys, he has all kinds of tools at his disposal. He has in his bonds revoked. Defendant's remanded.
And there it is. The decision comes down hard. Bond revoked. Defendant remanded. This is one of the most serious consequences in a pretrial setting. What it means, in simple terms, is that the court no longer trusts the defendant to remain compliant outside custody. So instead of giving him another opportunity, the judge removes that freedom entirely. And notice how quickly it happened. There wasn't a long debate, no extended back and forth. That tells you something important. The judge had already made up his mind based on the pattern of behavior. 15 missed tests, prior positives, lack of follow-through. That's a combination that signals instability to the court. And when stability is in question, judges tend to default to control. From the defense perspective, this is a worst-case outcome. They were asking for another chance, maybe stricter conditions, but instead they got full remand. So here's something to think about. At what point does a court stop giving chances and start enforcing consequences?
Your name?
Caitlin Quinn,
Oh.
Your Honor.
Judge, at this time, I have filed an appearance, substitution of attorneys, and an order for substitution, and a request for adjournment today because I was retained yesterday to get discovery from the defender's office.
All right. Without objection. Probable cause conference. Will January 29th work for you, sir?
Yes, it does, Judge.
January 29th, 2026, 9 a.m. Bond continued.
Well, Judge, wait, may I address that? Because she's still,
No.
the bond on the ROA says personal, and she's still in jail.
Hang on. Check.
I was confused why she would be there.
Yeah, Emily's looking right now.
I have it. I have it personal on the page. Yours shows what?
Right, yes. Which we have no objections to other than letting her go.
Is this her only case?
Yes, Judge, she has no priors.
Does she have a bond? But it doesn't say she's here on the bond, right?
While on bond, she's been testing. Her last test Thursday was negative. First test came back positive, and she said that's
Did you have a violation
that she
from January 7th.
that she is that the one you appealed, the January 7th one? And I think and she appealed it, and I don't know if they got the appeal results.
Now we shift into another case, and immediately you can see confusion around bond status. And this kind of confusion can be dangerous in court, not just for the defendant, but for the entire process. When attorneys and the court aren't aligned on whether someone should be in custody, it signals gaps in communication or documentation. And in legal proceedings, clarity is everything. Here the defense is trying to argue that the defendant should be out, that she has a personal bond, that she's been testing. But the court is digging into inconsistencies, positive tests, appeals, unclear results. It's messy, and judges don't like messy. They rely heavily on clean records and verified information. What's interesting here is how the defense tries to highlight the negative test, essentially saying, look, she's improving. But the judge is focused on the earlier positives, especially the mention of substances like cocaine and fentanyl. And that shifts the tone completely, because now it's not just about compliance, it's about risk level. So the key issue becomes, does one clean test outweigh multiple concerning ones?
Okay, so here's what I have.
Okay.
And the reason why she's in, her bond must have been changed. Did I issue a warrant on this? Or is she being held on that?
I think she's held.
Being held pending. Have you seen the bond violation?
I know that she tested positive, Judge.
Oh, she did.
Yeah, that's what they say, and then she appealed that. and those results are not back. And she tested negative last week when she was arrested on Thursday, and that was negative.
When did she? So on December 30th, you're saying there's a test after that one?
Did she indicate to me when you were incarcerated on the 8th?
When I got into jail.
Which she was taken into jail on the 8th. Were you out on bond before that?
Just recently, last Thursday, when I tested and got into jail.
Right. That's when you tested.
Yes, that's when I tested negative.
Is that the only test? Oh, that one was negative.
Yes.
Which one was negative?
She says when she went in on January 8th to the jail that one came back negative. But then there was one. Why would there be one prior to that? Were you already on bond?
Yeah, she was already on bond.
Okay.
She was supposed to be testing, and just so counsel's aware, on December 23rd, she tested for numerous things. Well, she was positive for THC, which I don't think she has a card for.
She indicates she does have a card, Judge.
Okay, she didn't present it to them, but there were other things.
Not the card.
But I don't think she has a card for cocaine.
No, Judge.
Okay.
She is on.
Doesn't have a card for cocaine. And if that's not bad enough, that was on the 23rd. On the 30th, and I'm getting older, so I don't know. Do they have a fentanyl card? Because that's what showed up on that date.
That's why I can test it.
That's the one that she contested.
That's the one she's contested. So
Yes.
Not the cocaine?
No, Your Honor, but she indicates she didn't use after on bond. She used immediately before bond. And I believe that was 6 days later.
She used the cocaine before she was placed on bond.
That's what she indicates to me, Judge.
Is it?
Yes, sir.
So when was December 17th, and it's showing up on the 23rd. Some good stuff.
What?
Just said it was-
Okay.
Yeah, that's right. I revoked her bond last time she was here
Okay.
because of those tests.
Very good.
I am not inclined to change it at this point. It's going to sit where it is.
Well, Judge, if I may,
If somebody needs to. Well,
This is a firm judicial stance, and it tells you exactly where the court stands. The judge is essentially saying, I've seen enough. I'm not convinced. Even with arguments about negative tests and contested results, the judge isn't willing to adjust bond. Why? Because uncertainty still exists. The fentanyl result is being challenged, and until that's resolved, the court is choosing caution over leniency. And that's a common judicial approach. When there's doubt, the court protects against risk rather than rewarding potential compliance. Notice also how the judge references reviewing future results. That's important. It shows the door isn't completely closed, but it's conditional. This is how courts maintain control while still allowing room for reconsideration. But here's the key takeaway. Once a judge forms an initial impression based on violations, it becomes very difficult to reverse that perception quickly. So the question is, should courts wait for perfect clarity before acting, or act early to prevent possible harm?
it's going to sit where it is until I get the results on the fentanyl. If she's contesting this, there's fentanyl in her system.
Okay.
What about my last test from when I got?
Yeah. What about the jail test on the 8th?
What?
What about her negative jail test?
I don't know. I don't have a report on the jail test.
Oh,
And I don't know what kind of test that was. I mean,
the
I don't
urine
know.
test?
Yeah,
Urine. So I'm assuming it was a drug panel.
it was like.
Right, but I don't know if it went over through our system at community corrections. I don't have a report on it.
Right.
So I don't know if it was clean or whether it was or not.
But she would continue to test, Judge, and I believe she would continue to test negative.
She had 3 tests. And 2 of those tests, I mean, absent her prescription medications, 2 of those tests were dirty for something. I'm not changing my decision. I will take a look at it again if I get that other test.
Okay.
Or whatever. If I get the other test that she says she took, if it meets with the certain standards, or if, I'll look at it. or if the results of the challenge to the fentanyl comes back, then I'll take a look at that certainly also.
We'll address that on the 29th. Then, Judge.
Yep.
Well,
Okay.
thank you for your time.
Thank you.
On behalf of Mr. John Brown, who stands to my right, please state your name for the record, sir.
John Brown, how you doing, Your Honor?
I'm doing very well, Mr. Brown. The court has before it a plea form. That's what we're doing today.
That is correct, Your Honor.
He's going to plead guilty to an added count 2 of use of a controlled substance, that being fentanyl, a misdemeanor punishable by up to 1 year. Upon successful plea to that charge, count 1 would be dismissed. And the sentencing judge waiver box isn't checked, but
Oh, I'm sorry, Your Honor.
Did you
We
explain
did
all of
go
that to
over
me?
that. Yes,
All
we
right.
did go over that, Your Honor. My mistake for not checking that box.
all right, very well. Can I have him sworn, please?
Raise your hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth? So you got it.
Yes, ma'am.
Lower your hand, state and spell your name.
John Brown.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of fentanyl. That is a misdemeanor punishable by up to 1 year incarceration and a $2,000 fine plus court costs. Do you understand that?
Yes, sir.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes, sir.
You understand that?
Yes.
All right. Still wish to plead guilty
Yes.
to that charge? How do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
Now we move into a completely different phase, a guilty plea. And this is where things become more structured and procedural. When a defendant pleads guilty, the court has to ensure that the plea is made knowingly, voluntarily, and intelligently. That's why you hear the judge asking a series of questions about rights, understanding, and potential consequences. This isn't just formality, it's a legal safeguard. Because once a plea is entered, it's extremely difficult to take it back. What's also important here is the charge, use of fentanyl. Even as a misdemeanor, it carries serious weight, especially when tied to probation status. And the judge makes that very clear. This plea could trigger a violation in another case. That means the consequences extend beyond just this charge. It can affect the defendant's entire legal situation. So while the plea might seem like a resolution, it's actually just the beginning of another phase, sentencing. And here's something to consider. Is pleading guilty always the safest move? Or can it sometimes open the door to even bigger consequences?
All right. You signed an advice of rights form or went over one with your counsel?
Yes.
Any questions regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of it.
Yes, Your Honor.
Are you on probation or parole?
I am on probation.
Were you on probation at the time of this offense?
No. Yes, I was.
You were? Okay. I do have to advise you then that your guilty plea in this case could be considered a violation of your probation. You understand?
Yes, I've spoken with my probation officer. She knows what's going on.
All right. I have to advise you that if it is considered a violation, that court could sentence you to the maximum allowable under that other charge. You understand that?
Yes, sir.
All right. And understanding that, you still wish to plead guilty to this charge?
Yes, Your Honor.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes,
and because you believe that you are indeed guilty of this offense?
I am guilty.
January 24th, 2025, at the location of 49230 Michigan Avenue in Ypsilanti Township, Washington County, State of Michigan. Did you have fentanyl in your possession?
Yes.
Had you used it?
It was in pill form. I didn't at the time. I didn't know it was fentanyl, but yes, I did take one. Yes.
So you didn't know you had fentanyl in your possession?
It was in a Percocet form. I thought I had bought a Percocet pill.
So you didn't know what you were using was fentanyl?
Ignorant. Nope, didn't know.
But you knew, okay, but it was a Percocet you thought you were taking.
Yes, I knew it was illegal that I didn't have a prescription
You
for
did
it.
not have a prescription for it. And so you were in possession of a controlled substance that you shouldn't have been in possession of,
Yes,
correct?
sir.
All right, then there's a number of ways I can do it. Higher.
Yes, Your Honor, I would ask
Take
that take plea to the higher the
All right,
charge.
sir, if I accept your plea, I need to apprise you that if you commit misconduct as defined under Michigan court rules between the time of my acceptance of your plea and the time of your sentencing, the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
I understand, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And has the court complied with the court?
People are satisfied, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 14B probation. Sentencing will be
10 a.m. Washington.
February 12, 2026, 10 a.m. before Judge Washington.
Your Honor, may I address bond when appropriate?
I don't know if it's appropriate or not, but go ahead.
Thank you, Your Honor. It is my understanding, I was not the attorney at the last probable cause conference, but it is my understanding that Mr. Brown was remanded at the last hearing for a community corrections bond violation. It's my understanding he's been in jail a week on that violation, and the basis of it was 2 missed tests, as well as I believe a test that was positive for THC. I have spoken about this to my client. He, of course, admits to the bond violation. He did appear last week in court knowing that he was likely to be remanded on the bond violation. I do not believe him to be a flight risk. He does have a residence where he lives with his girlfriend and 4 children, ages 16, 14, 3, and 11 months in Taylor, Michigan. He further has full-time work doing cement and flooring. He's a finisher. He is asking if the court would consider reinstating his personal recognizance bond. He is willing to do anything that the court obviously orders. He understands he cannot have a single more missed test. It's my understanding his positive test didn't have anything else positive besides the THC. He's willing to go on tether. My client even told me he'd be willing to do house arrest. I advised him that is likely not the appropriate sanction the court would issue. However, he understands he's not to do substances. He needs to.
I'm not going to change his bond. What he's going to need to do is he's going to need to talk to the probation department there.
This moment is emotionally heavy, and you can feel the shift immediately. The defendant isn't speaking through an attorney anymore. He's speaking directly to the judge, appealing on a human level. He brings up his job, his children, financial pressure, all real, all impactful. But here's the harsh truth. Courts don't make decisions based purely on sympathy. The judge acknowledges the situation but stays firm. Why? Because the decision isn't about hardship, it's about compliance and risk. From the court's perspective, the defendant already had opportunities and didn't meet the conditions. So now, the focus shifts from giving chances to enforcing structure. What's interesting is the mention of probation and future review. The judge isn't completely closing the door, but he's making it clear that any change will come through proper channels. Any not emotional appeals in the moment. This is where law and reality collide, personal struggle versus legal responsibility. So ask yourself, should personal circumstances influence legal decisions more? Or should the law remain strictly consistent?
And then in Judge Washington's good wisdom, decide to change his bond.
Understood, Your Honor.
Your Honor, first I understand you say you're not going to change my bond. I just want to apologize
But
to the
you're
court.
still going to ask me? No.
Yeah, I just want to apologize to the court for my ignorance and not knowing that I was supposed to go over there. But I really need to get back to work. Like I'm down. I'm willing to go on tether, whatever. I just want to be able to get back to work. Right now, my girl's not working. I got 4 kids at home. Very, very high rent.
Okay, sir. What I've indicated, and your counsel knows how to get through to 14B. They can contact 14B, get you interviewed, and then get to Judge Washington to reset your bond. But at this point, I'm not changing your bond. Thank you.
Thank you, Your Honor.
Court calls case People versus Jaleesa Robinson.
This hearing brings together multiple stories, but they all revolve around one central theme: accountability under pressure. We saw a defendant lose bond due to repeated violations, another struggling with conflicting test results, and a third entering a guilty plea that could impact multiple aspects of his legal standing. And throughout all of it, Judge Simpson remains consistent, focused on compliance, evidence, and risk assessment. Not emotion, not excuses, but patterns and responsibility. That's what defines courtroom outcomes. It's not just what you say, it's what you've done consistently over time. The legal system can offer opportunities, but it also enforces consequences when those opportunities aren't taken seriously. And that's the real takeaway from this case. Every decision, every missed test, every action or inaction builds a narrative that the court ultimately judges. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.